next we have Shannon Tufts from the UNC School of Government talking about GIS data disclaimers.
Does anybody have questions for them while we set up?
Yeah, if you don't mind, if you got it.
Oh, yeah, definitely.
Maybe just one question for an hour or two. Any questions? No? Okay.
Out where everybody's from. Who is public sector, state governmental, of some sort? The rest of you are private sector? You're just the bigger ways of okay, so some of you from the private sector may not know about the school of government, maybe some of you from the public sector don't know about the school of government, but this is where I work. I'm a faculty member at the school of government at UNC. What we do actually is probably pretty unique compared to anybody in the country. We offer direct service assistance to local government, state agencies, even just general citizens or private sector companies on a variety of topics. And so most of our faculty are lawyers. We have about 70 lawyers, and then there's a smattering of people like me that pretend like they're lawyers at times, they're actually just PhDs. And so when I was asked to teach on this topic, it was really something I absolutely knew nothing about. And so I will tell you that straight up. What I typically would teach on is public records law and things like that related to North Carolina data. But I did some research to try to figure it out. And so as we go through this, there may be times where you have questions. I will try to answer any question that you have. If I can't, I will write it down and then send it to one of our attorneys that they can answer the question. But just to give you a heads up, this is going to be the best slide you all day. Promise you. It's going to be boring because there is no way to make GIS disclaimers interesting under any circumstances. I don't know if you'll learn anything. It's going to make you dangerous if you do learn something. It is not legal advice, and the answer is always a 10. That is the only thing I have known. Is anybody here an attorney? Drummer. If they would tell you that is true. Every answer to that is it's a 10. So now, what kind of questions? Why are you sitting here? Is there something you want to know about GIS disclaimers other than what they should look like? Anybody run into a problem where you have been threatened with litigation over the data that you provide? You're just here for this reason and the optimism. Real speak up. Okay, please.
Not you personally, but
okay, so you're a planning agency that's had active implementation for transportation projects. Now, are you have surveyors on your team? Okay, so there is a different standard that is held by the average GIS professional, right? All of us, not all accountants, all of you are GIS professionals, fall under what's considered like a reasonable citizen approach. Right? If you don't have the same standards that a surveyor would have in terms of professional licensing and responsibility. So that's number one. Did any of the actions taken against you lead to y'all having to pay out? Yes, you've been able to successfully defend against all actions taken against you. Yeah, as far as you know, or you settle, right? So sometimes there might be. And so the typical action taken against you would be somebody saying that your data was wrong.
Or that
the method calculated was wrong. So those are the kinds of things we'll probably cover in some of these cases. I'm going to specifically talk about data that is typically rendered to the public or some subset of the public. You go online, I use IMAPs all the time. I live in this kind of different and talk about the work that they do. And so I go into IMAPs on a regular basis. I go into almost every GIS system that they have and check them out and search around and see what's out there. And so what I will say is I'm thinking more in the vein of that area but if there are public, private questions, private sector questions, we can probably get into those. Here is your standard disclaimer that you would be, I did not see anybody from the state of North Carolina. Because I didn't want to offend anyone or make fun of anybody here. So we will talk about this. I will tell you every time I read any disclaimers or limitations on liability, et cetera, we need a lot about contracting law for IT procurement, things like that. But basically, actually, we saw some of the same language in the presentation from Malcolm, right? It's on an as-is basis. There is a statement about fitness for particular use. It goes on and says we're not going to be held liable for any consequential, incidental, special, or they call it exemplary, sometimes punitive damages. Even if you've been told that no damages might happen, right? That is like the get out of jail free card in every limitation statement that I've ever seen. They go on and say we're not going to guarantee that there's not deficiencies. And this is the DOT from Colorado saying we can't guarantee anything, right? And that you have to make sure that the data is accurate. That one is okay. So those of you who have these kind of disclaimers, does yours look something like this saying we don't verify the accuracy, don't use it for good, decision making on where to put up the fence? I actually was thinking about that recently. I was looking at Wake County, my property on Wake County, and I thought, I really just want to put up a fence. So my dog stopped trying to go against the neighbor's dog, and then I thought, I just put there. Because I can't build a fence based off of what they have. So, not because it might not be correct, because they don't have the legal authority to guarantee that it's correct. And then if my fence is in the wrong place, guess who's at fault? Me, not Wake County, right? So here are some better options that I think make more sense. And I'm going to stress all of you out when you see how many things you probably need to be covering with your disclaimers. We will make these available, yes, okay. And if you want sample after sample language beyond what I have here, I have some of them that I pulled down. So we're going to start off. Oh, yeah. Am I not on? You got all my jokes. Is there recording yet? I missed the funny slide at the beginning. So yeah, I might have to end with that again. Okay, so we're going to talk about these ideas of the disclaimers that you probably do want to have in there. So here's your standard terms and conditions. Now, I have a slide at the end that's going to talk about how you put these out there. How many of you are using browser wrap licensing notice or end user consent? Do y'all know what that means, browserware? Is that what you're using? Okay, yep, browserware means it's posted on the site. Versus clickware, what's the difference? Or a click wrap? So go back, okay, I'm old, we're gonna go back. Y'all remember when we used to get software sent to us and it was wrapped in shrink wrap? Does anybody remember that? And you had to open it. He's looking at me like, I have never heard of that. I am way too young for this. And so you had to open it. And at the top of that software little CD was a statement about the licensing. So that's called shrink wrap licensing. Click wrap means what? What would you assume? You have to click an acceptance, right? There's a little box. So Facebook is a good example. Is everybody here on Facebook? Have you ever read the terms and conditions associated with Facebook? You would not be on Facebook if you read them. It's terrifying, actually. And so when you go onto Facebook, there's a little button that you click and you say, I've read the acceptable terms, the terms and conditions, right? The acceptable use statements, and I consent. I consent to you having all my data, selling all my data, et cetera, et cetera. And so that is clickware or click wrap licensing. The difference is pretty interesting from a legal standpoint. The courts have consistently held that click wrap licensing, where you actively do an action to proceed, is completely defensible from a court proceeding. So if the user says, I was not aware, the court's going to say, too bad, you clicked the little button. How is yours noticed on the site? You said it's browserware, basically. And so when you go on the site, what happens? Okay, so you've got two disclaimers. So you've got both the click wrap version and the browserware. Does anybody have just the browser sort of option where there's notice given, maybe it's a hyperlink to a statement or something along those lines? If you're doing that and you get into litigation over them saying we didn't know the rules, right? What's going to happen is, number one, you're going to have to get on a stand and try to prove that they did have definitive knowledge of what the rules were. And so that's a little bit difficult, unless it's somebody who's used your software over and over and over and over and over again, and then you would be able to probably prove that. The second thing that will happen is you're also going to have to, ideally, if it's in a bright font or some sort of call-out text that is different than everything else on the site, the courts have typically ruled in favor of those types where you literally could not avoid seeing the statements about what you were supposed to do, right? So maybe it's in a different shading, it's in a call-out box of some sort, but that's the way that I would recommend thinking about that. So here's your standard terms, right? It says, we're giving this data to you as without a charge, right? Because we know that GIS data has to be produced, at least in North Carolina, for relatively free. I say relatively free because if you're asking for actual physical copy of it, you can charge a reasonable cost. You can, in the state of North Carolina, make someone sign a form that states that they're not going to reproduce it for commercial or trade purposes. And if they're going to reproduce it for that, you can charge them plenty, right? Because it's your data and you own it. And so it goes on and says, if you don't accept these terms, you can't use this data, right? So this is the first step in this process. Then it goes further. Here's a really good, really legal definition of warranty and accuracy. So what they're saying is, again, is as is and with all faults. That means they know it's not perfect, you know it's not perfect, everybody's in agreement that it's not perfect. They go on and say that it's making no warranty, express or implied, about the fitness, similar language that we saw in the first slide as well as in the slide from Boundless. And they go on and say no legal liability, that it is not intended to constitute advice, nor should it be substituted for advice from a professional. That's where they're protecting themselves against me going out and building a fence based on the polygon that I find on iMaps, right? And so that's something that you would want to pay attention to. They tell you to not go in and do any actions based on this, and that the users are responsible for making sure that it makes sense and that they're going to verify the data. And it talks about the fact that the data can be modified regularly over time without knowledge. Then we get even further down the path. And actually, this is on a document that I saw from multiple different jurisdictions outside the state of North Carolina, where they have basically piecemealed all of these different statements together. And the way that they're doing it is probably similar to what you've got. They're doing like a click to OK, and there's a hyperlink that takes you to a giant document, like Facebook style. It's not 72 pages long. It literally is like 1 or 2 pages long that states all of these things. And so they go on and say, we're not going to give you any sort of damages for you losing money or whatever based on this, and they indemnify themselves and the users. So it goes on from the limitations of liability. Now, there's some more that they do, and I really liked a few of these. This one I had not seen before until I started researching this. I've talked about the other ones all the time in classes. I had not seen this one, which is stating that you do not have the right to represent the organization as a function of using this data. I had not thought about that before, but I thought it was a pretty good idea. It's similar to not being able to use somebody's trademark or something along those lines, but they're basically, apparently there have been cases where people have then taken that information related to this data that's presented and then represented as if they were a county employee, right? They represented on behalf. And so in the case of like contract law, you would talk about transference, right? So do I have a subcontractor, and can the subcontractor act on my behalf? And do I transfer the responsibility down to them for ensuring that I hold the contract as it was supposed to be held or not? They also say, and this one is, I was thinking about Wake County actually, because when I was talking about the fencing, this one states, and it's a little different, right? Because this is actually one that I pulled from Europe, where they're talking about, we don't represent these shapes that you see on our maps are actually reflective of boundaries or frontiers, right? Official lines. But I thought that it was interesting because think about it. If you've got schools, right? You've got Wake County schools and you've got Wake County data. What if you're right on the line? And what if the data competes in two different cases? Because school system doesn't always use the county data from what I understand in talking to the school system. Maybe they should, but they don't. So who wins, right? In both of cases, you would not want the county to be able to get sued because you say they're in your county and then Franklin County also claims them. In Wake County, that's a common border dispute that we have. Data accuracy tells you that they are going to update it regularly and they are not going to provide assurances that it's accurate. If attorneys write this stuff for you, just know that these are the best get out of jail free cards that you can possibly get in a lot of ways because you're going to protect yourself. Termination of data availability. I like this one a lot. This one states that, and this is something, I don't know from your open data platforms that you guys have put out there, if it's something that Wake County has covered. Anybody else here doing open data? So where are you from? Okay, DEQ. Where are you from? C of A. Okay, so is anybody from Asheville? You're from Asheville, from the city? Okay, but so I know more about Asheville's open data because I've been down or up to Asheville and seen some of the things that they're doing. And one of the things that we have wrestled with for a long time in government is if we provide an open data portal and then people mine that data and do business related decision making with that data, what is the liability on the government, right? And what if I decide to stop collecting that data? And somebody has built an entire business model on me providing that data to them, and that's how they make their money. Nobody else worries about this? I worry about this. So everybody else seems like, yeah, whatever. But at the end of the day, if you have a termination statement that says at any time we can just stop providing the data, stop collecting the data. I mean, think about the things that we collect on a regular basis that maybe will get outmoded eventually because times change and we don't have to collect that type of data. So if we state that there's no guarantee that this data is going to be provided for the rest of your life, by the way, Facebook does this too. They tell you they can cancel you at any time. They can delete every bit of your data at any time. They can stop providing Facebook in general at any time, right? So it could be individual or just grand scale. And you have no rights to anything. Take the Facebook licensing agreements, copy them, because they are written by attorneys much more expensive than anybody in this room could afford, right, for the most part, and then put them out there. They also state that we can terminate you as an individual from using our data, especially if you're reproducing the data, if you violate the terms of use. And we're going to talk about the terms of use towards the end when we get back into that click wrap browserware sort of discussion. Okay, reliability of the site. Now, some of you are using a hosted solution. I was not picking on ESRI, or I could pick on any number of them. But if you have a hosted solution, what they also state is we are not responsible for ensuring that this hosted solution is up and running all the time because it's outside of our hands, which I thought was pretty handy. I probably would say, so DEQ, I would say we are not responsible for ITS or DIT or whatever they're called today. If they're hosting your environment in the Western Data Center, I don't know if they are, but I'm just extrapolating out. We are not responsible because that is a third party, even though it's still the state of North Carolina, that is providing that service to us. So we can't ensure that it is going to be up at all times, right? So that might be something that you want to think about. Okay, I already sort of laid out this idea about click wrap and browserware. So here's the actual official definitions of click wrap. Click wrap requires a visitor to indicate their agreement by clicking an accept or an OK or a little box or something. There is a physical action they have to take to go further. The courts have held, again, consistently that click wrap or clickware licensing is a clear license that you as a user know about. And so when you claim, I didn't know about it, and there's actually a case using Facebook. So somebody in New York City, or New York, not New York City, sued Facebook for stating that they were unaware that Facebook was mining their data, that they owned their data, that they were going to then advertise to them specific based on what they were browser history showed and things like that. So this guy sues. The court said every time you log on, there's a box that you click. And by simply telling Facebook to remember your logins or telling your browser to remember your logins does not mean that you aren't still consistently aware that that acceptance has happened. So how often do the users need to accept this? You say once? So the problem with this is the court doesn't know. And so I told you it depends. It depends on how savvy the judge is that you get probably in these cases. I don't think once is enough, and I'll tell you why. It has nothing to do with GIS disclaimers. It has to do with the history of the courts and rulings around something called the Stored Communications Act. Y'all are getting way more knowledge than you thought you were coming to get GIS knowledge. This is nothing about GIS. This is a federal wiretap act that was put in place in the Cold War. What it has done is, how many of you are using a cloud provider for anything like email or any app on your phone? So interestingly enough, the government is not allowed to require those cloud providers to give up data about you without court order. So when you work in a government and you have a third party that provides your email solution, like let's say you have Gmail for government, right? Does anybody have Gmail for government or Gmail for business or whatever? One of the things that you've done is you have signed an agreement that states that I, as the administrator of the account, right, I, as the organization, must maintain end user consent. End user consent is that click wrap, right? Every time I log on, I hit that button and I say, yes, I'm going to do that. The courts have held that once is not enough, that if you signed a waiver of what we would call your Fourth Amendment rights, your right to privacy, if you sign a waiver stating you have no right to privacy and you signed it 15 years ago when you started your job, that is not sufficient. They have not said that it has to be every time you log on. I like to err on the side of every time you log on, right? If there's a quick little IT fix that we can put in there with every time I hit the OK button, then I'm going to do that all day long. If it's once a year, so for employees, they say at least probably once a year. But for the citizen, I would say it needs to be close to every time they log on, right? If they're caching and they're able to do that to get around it, or they're using some sort of web crawler, the courts have actually held with the web crawlers themselves that if the web crawler is crawling and there is still that clickware that's there, that the web crawler is consenting to understanding what the licensing is or the terms of use are. And where it gets really interesting is then in the terms of use, if it states that automatic collection is not allowed, because I think Bill was saying that, was it you saying that Chinese are sniffing your site? Oh, was that the other guy from Boundless, maybe? The Chinese are sniffing and grabbing little thumbnails. No, somebody was talking about it right here. Okay, so yeah, she was, see, Carter backed me up. Yes. And so one of the things, I mean, I'm not picking on the Chinese, it's just what was said. And so one of the things that we know is that the courts will come down and say, you breached the terms of use because you are using an automatic collection vehicle, or because you're then redistributing it for commercial purposes, right? Which is actually, yeah, it was definitely Anthony because he was talking about reverse engineering of the software. So that's something that you'll want to pay attention to. But I do think it needs to be more than once. It probably needs to be as close to every time. Yes, sir. Okay. Fourth Amendment rights, yes. Yes. Yeah, so he's talking about how in Canada they have a privacy commission that comes after you if you as a private company or a public company, a government, aren't taking care of data that is in your ward basically about private citizens. And Europe is even more strict. So what's your question, or is it a comment? Yeah, the US has nothing like that. Yes, yes. So, I agree with you. In most countries, you cannot do that. In the United States, we err on the side of less privacy, I would say. He's like, yes, I'm going back to Canada as fast as possible. But it's one of those things where in the United States, the Fourth Amendment is only protection against the government doing unreasonable search and seizure. And so it's the government coming in and invading. So if the private companies can do whatever they want, assuming you've signed a consent that says y'all can do whatever you want. That's why Gmail is free, is because they mine your data, they sell your data, and then you get advertisements sent to you based on that data. I agree with you. It's a kind of a travesty. Now, I will say, we do have other laws in every state in the United States, as well as at the federal level, that's around identity theft protection. So here in North Carolina, it's the North Carolina Identity Theft Protection Act of 2005. So it's an old law that states that there's certain types of data that if it is breached, you must provide notice to the people who possibly were hit by this breach. You must provide monitoring services for their identity, kind of monitoring services, etc. It lays out those things, but everything you're putting out on GIS typically is protected. I mean, is public, right? It's not protected things that you would have. However, there is a caveat to that. Those of you who are in government, do you know about the law related to law enforcement officers' identifications? So some of you are like, yep, we've never heard of it. If you're in the government space, this particularly matters, but you are not allowed now, we believe. The problem is when we write laws is that we don't have good understanding of what the law is actually trying to say. But basically, you're not supposed to release things like name, telephone number, address of law enforcement officers. So those of you who have GIS systems that are tied in to property tax records, are you actively pulling out that data for law enforcement? Carter's like, she doesn't know, which is fine. It's not your job, actually. It may be that the law enforcement, so we don't have any court cases on it. It was written by the General Assembly in 2015. They state that this protection should happen. They talk about personnel files is what they're largely concerned about. But then there's this broader implication for property tax records and GIS records. And so I actually just talked to a jurisdiction 2 days ago where he asked me, the IT director asked me, because he does GIS as well underneath him, if they had to remove it because the sheriff's department had requested it, that all of their deputies have everything removed from the property tax and GIS systems. And I said, well, based on a broad interpretation of the law, the answer would be yes. He had not heard of the law. If somebody hasn't asked you about it yet, maybe you can let it go. I don't know. I don't think that's necessarily the best thing to do, but it's something you probably have to pay attention to. There has been some interesting legal play involving these web crawlers, as I said before, and commercial use restrictions, where we are starting to see that those disclaimers are really important in that space of figuring out how not to give up that data or allow automatic web crawlers to hit you without you being able to claim that they're breaching the terms of use, because you state clearly that they're not allowed to do that, and then you can terminate their access points, right? So you can make it to where they can't get access. It's a little more difficult to do in practice than it is, right? But you can actually win litigation on those cases. Okay, what are your questions? Now that I have bored you with everything possible. Yes, ma'am. Okay. So when you're are you a government? Okay, so when you're emailing so her question's around when you're emailing or a thumb drive with data on it, right? Is that, or sharing on your own servers? So are you asking about public records or about disclaimers? So would they be available to the public? Sort of, yeah. Okay. Yes. Are you verifying in some way, shape, or form? Right. I actually would build that disclaimer in, and so the idea is that you want a disclaimer that is associated with the data set. I would build that disclaimer into my email, right? Because then they can't say they didn't see it. I would literally cut and paste it, just like you do at the bottom of your emails. Anything you send or receive may constitute a public record, or if you're in the private sector, whatever communications we have are privileged and confidential and cannot be redistributed, blah, 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 blah. So I would just put it in the email itself. Even if you put a hyperlink, and so the hyperlinks actually are a useful way to do this, right? You build a form, you have all the data on there, you use the hyperlink, and you use the clickware basically with the hyperlinks, because it's, again, their responsibility to click on that link. And so I would just put in the body of the email, or on the server, swap, or whatever, we don't warranty that the information is accurate. Without opening the email itself? Right. Could you put a splash page on the front of that data before they get access to it? No. So it's just a file that's like, well, I would put it on, if it's like a SharePoint site or something like that. So it's database to database. I would do it in my employee manual. Nobody reads it. Nobody reads it. I understand that, but ideally they should be having annual security training, right? Everybody should be having that annual security training, because what I said earlier was we also should be collecting a waiver of Fourth Amendment rights annually, most likely. And so I would put it in there as well. And that way they can't say that they didn't know. That's my, oh, there you go. Well, then I think you're probably fine. If it says read me and they choose not to read me, right? That's like putting together a Lego set without reading the instructions. You can't then claim to the Lego company that they built it wrong, because you have to read the instructions. I don't know why that was the analogy I used. I have an 8-year-old. This is what we do. I think you should say read me important disclaimers regarding accuracy or something along those lines. Does that make sense? I don't know where we're at on time. Do I need to stop? Okay, I got to stop. I'll hang out right here if you want to come up and talk to me individually afterwards. Sorry, Carter.